Get ready for the dictation. Start. One of the apparent and unavoidable consequences of reading the provisions of Section 11A of the Central Act into the State Act would be that it is bound to adversely affect the development scheme under the State Act and may even frustrate the same stop. It is a self-defeating argument that the government can always issue fresh declaration and the acquisition in all cases should lapse in terms of Section 11A of the Central Act stop. The argument also does not stand when tested on the touchstone of the principles test of unworkability, test of intention, and test of frustration of the object of the principal legislation stop. As per the scheme of the two acts, the conclusion has to be that they can be construed and applied harmoniously to achieve the object of the State Act, and it is not the requirement of the same that provisions of Section 11A of the Central Act should be read into the State Act stop. The obvious animus is that the provisions providing time frames, defaults, and consequences thereof which are likely to have adverse effect on the development schemes were intended to be excluded stop. Thus, it will be clear that the provisions relating to acquisition like passing of an award, payment of compensation, and the legal remedies available under the Central Act would have to be applied to the acquisitions under the State Act, but the bar contained in subsection 6 and 11A of the Central Act cannot be made an integral part of the State Act, as the State Act itself has provided specific time frames under its various provisions as well as consequences of default thereto stop. The scheme thus does not admit such incorporation stop. The BDA Act has already been held to be a valid law by this court, not repugnant to the Land Acquisition Act, as they operate in their respective fields without any conflict stop. For the reasons stated in different decision as well as the detailed reasons given in the case of Girnar Traders third, which reasoning would form part of this judgment, it is concluded that the BDA Act is a self-contained code stop. The language of Section 36 of the BDA Act clearly mandates legislation by incorporation, and as per the scheme of the two acts, effective and complete implementation of the state law without any conflict is possible stop. The object of the state law being planned development acquisition is merely incidental thereto, and therefore such an approach does not offend any of the known principles of statutory interpretation stop. The respondents engaged in the business of import of rough marble blocks classifiable under subheading 15.12 of the Customs Tariff Act 1975 stop. The goods imported by them were confiscated under section 111 of the Act stop. They were given option to redeem the goods on payment of redemption fine, which was fixed, adopting the margin of profit as the basis under section 125 with penalty levied under section 112 of the Act stop. The appeals of importers were partly allowed by the Customs, Excise and Gold Control Appellate Tribunal, observing that the facts in each case were similar to those in Messrs. Stoneman Marble Industries versus Commissioner of Customs, decided on 30th January 2002, and therefore reduced the redemption fine and penalty to 20% and 5% of the CIF value respectively stop. The revenue filed an application under section 130A of the Act before the High Court, stating the questions for reference by the tribunal to the High Court stop. The High Court rejected the applications on the ground that no question of law arose from orders of the tribunal stop. Aggrieved revenue filed the appeals stop on a bare perusal of the provisions of section 130A of the Customs Tariff Act 1975. It is manifest that it is for the party applying for reference to clearly state the question of law which the seeks to be referred to the High Court, and then it is for the High Court to consider whether any such question of law stated in the application for reference before it should be directed to be referred stop. In the instant cases, it is manifest from the format of the questions proposed by the revenue for reference to the High Court that the revenue did not assail the tribunal's finding to the effect that the facts in the instant cases were similar to those in Messrs. Stoneman Marble Industries stop. It is a trite proposition that unless the correctness of facts on the basis whereof an inference is drawn by the tribunal is put in issue, a question of law does not arise from its order in any way. Stop.